Welcome to the podcast summary of our class on state immunity in public international law. The aim of this podcast is to give you an overview of some of the concepts and cases we'll be talking about in our class on immunity. So the way I want to divide this up is to first outline the structure of what we're going to do, and then talk about the basic underlying policy, and then run through a number of the key cases. So the basic structure I'd like you to think about is threefold. First, a case can be brought in a court against a state directly or one of its agents or organs. So against the state or against an agent. Second, cases could be about civil or criminal responsibility. And third, cases could be brought at the national or international level. So bear in mind always this question of are we dealing with the state or its agent, but the four basic categories I'll be talking about are civil cases before national courts and international courts, criminal cases before national courts and before international courts. So those are the four categories. Now before we go into those, I want to posit one of my basic rules, a basic rule that underlies everything else that we're talking about. And that is the idea that a state is absolutely immune from the jurisdiction of foreign courts unless an exception applies, as summarized in the Latin phrase parem parem non habet imperium. The idea there is that an equal cannot exercise power or authority over another equal. So, at least in theory, for a national court to adjudicate on the liability of a foreign state is for that national court to assert that it is superior to the foreign state, which would violate the principle of sovereign equality. 2 points to note about this. First, as I've said, you are absolutely immune as a state unless an exception applies, and we'll be spending some time on those exceptions. The second point to bear in mind is that immunity does not extinguish liability. There's a difference here of procedure and substance. So when you breach a legal obligation, you are substantively liable. Even if you can plead a procedural immunity, that does not extinguish the underlying wrong and the legal obligations arising from it. All a rule of immunity does is say, this court cannot hear this case at this time. But that logically means that there might be another court or another set of circumstances or another time where the case could be heard. All right, let's go through my four categories then. Civil cases before national courts. The basic idea here is that, for example, the Embassy of Austria buys furniture. A local trader tries to sue the embassy and discovers, at least under the old absolute rule, that it can't. Now this creates potentially hardship for the trader and inconvenience for the embassy, because it might suddenly discover that no one is willing to sell it furniture if it can never be sued on its debts. So what we find is, over the course of the 19th century in particular, a rising exception to the general rule of absolute immunity in the case of ordinary commercial transactions. So this leads to a distinction that's commonly made in customary international law between the ideas of acts iure imperii, acts done with sovereign authority, and acts iure gestionis, that is, acts any ordinary person could carry out. That is a distinction that becomes a little difficult to apply in practice, as we'll see, in that there might be perfectly ordinary acts that are being done for a sovereign purpose, and how do you classify those? We'll also look at the UK State Immunity Act of 1978, which basically sets up a very wide exception for contracts and financial transactions that resolve a lot of those questions about characterising something as an act jure imperii or jure gestionis. The other point that it's important to note is that there can be immunity in civil cases arising out of an international crime, essentially where someone, for example, sues their torturer. So two cases that we'll look at will be Al-Adsani and Jones and Saudi Arabia. Al-Adsani before the European Court of Human Rights, Jones and Saudi Arabia before the House of Lords. These were essentially decided on the theory that there is in the law of immunity a distinction between procedure and substance, that the substantive liability was not extinguished, but the national courts in question were simply not competent to hear the case. However, that is under challenge from some contrary case law, such as Farini in Germany, which concerned civil liability for acts arising out of war crimes committed by German forces in Italian territory, where the theory articulated was, well, if international crimes are contrary to jus cogens, and jus cogens trumps all other rules of international law, surely jus cogens should also trump rules of state immunity. So we have some conflicting authority there, but the balance of authority at the moment seems to support the continuing idea that you can have liability in civil actions against the state or its agents. All right, now let's consider the case of civil claims before international tribunals. The point here is that what we'd think of as civil claims at the international level is really international dispute settlement. It's questions of state-to-state responsibility. And the object of state immunity is to prevent a case being heard against a sovereign without its consent. However, the basic rule of international dispute settlement is that a state can only be brought before a court or tribunal with its consent. Therefore, there's no rule of immunity in effect for international civil cases, say before the International Court of Justice. The question will just be one of the court's jurisdiction. And these issues will be covered in our class on dispute resolution. Now, let's talk about criminal cases. So it's commonly said that there can be no immunity for international crimes, and that is at the very least an oversimplification and very possibly wrong. But we need to distinguish between two different types of immunity here. First, the idea of immunity ratione personae, which is the idea that certain serving high office holders are absolutely immune from the jurisdiction of foreign courts and may not be subject to any aspect of criminal procedure. So they can't be arrested, they can't be claimed against in a civil action, they can't even have an arrest warrant circulated mentioning them, and they cannot be, for example, subpoenaed, because all of this would either compromise their ability to do their job, say as head of state or foreign minister, or compromises the dignity of the state. And we'll be looking at the arrest warrant and Djibouti and France cases to cover that. However, the point about immunity ratione personae is that it is limited in time. It only covers you while you're in office, but while you're in office it's absolute. And it also covers only this limited class of individuals, certain high office holders who are close to the status of, say, a visiting foreign minister or a head of state. We then have a separate type of immunity, immunity ratione materiae, or official acts immunity. So this is the idea that all individuals will enjoy state immunity in respect of their official acts. And this covers you not only in your time of office, but once you leave office. It attaches to the act itself. So it's capable of covering past conduct. Now, the important point here is, as with immunity ratione personae, the immunity belongs to the state, not the person. So it can be waived. The state can waive it. And this can be done also by necessary implication arising out of a treaty. And the key case we'll be discussing there is Pinochet number 3, in which it was held that on the narrowest reading, the terms of the Torture Convention meant that states must have implicitly, or by the direct effect of the words used in the treaty, have intended that officials could not benefit from state immunity for acts of torture because torture was itself defined as an act committed by officials. However, what arrest warrant is very clear about is that at least immunity ratione personae, and probably implicitly immunity ratione materiae, are available for international crimes. And so we come back to this question, well, why should you be able to plead immunity in respect of jus cogens violations? And the ICJ gives the procedure versus substance answer. They say, well, what we're talking about is not impunity, it's simply immunity. So while this case cannot be heard by a national court now, it could be heard by a court in the state where the official lives, where they reside. It could be heard before an international court with appropriate jurisdiction, or it could be heard if, for example, the state waives the immunity. And we'll go into whether that's a full answer and whether the answers given by the ICJ are in any event particularly convincing. Let's very briefly cover immunities before international criminal tribunals. So it's occasionally suggested that there is no immunity for persons accused of international crimes appearing before international tribunals. And the strongest cases there are Prosecutor and Blaskich at the ICTY and the Charles Taylor case before the Special Court for Sierra Leone. So the essential idea here is, well, these courts operate on the international plane. These are international crimes. Immunities exist before national courts, so why should they exist at the international level? Or in the alternative, the kind of jus cogens argument we've already made, well, there should simply be no immunity for these crimes under any circumstances. So you'll find a number of cases that make this sweeping proposition: we're an international court, we are not bound by the ordinary rules of state immunity. The situation may be more complicated than that and may depend on the origin of the tribunal. For example, the Chapter 7 powers of the Security Council can clearly set aside something like state immunity. But if this proposition of no immunity before international courts is true, we have to ask a question about, well, what's an international court? So, for example, could Britain, France and Italy set up the European Court for African War Crimes and claim that there is no immunity for foreign officials before that court? That would lead us to a question of, well, if these states couldn't do that at the national level, if they couldn't do it using their own jurisdictional powers, how can they, by clubbing together, do something collectively they couldn't do individually? So the answer probably, if it's true to say that there is no immunity before international courts for international crimes, probably has more to do with the special representative character of the United Nations or the particular powers of the Security Council under Chapter 7. We'll also examine the position before the International Criminal Court, where Article 27 suggests there's no immunity before the court, but Article 98 actually suggests that immunity would be respected in proceedings to surrender someone to the court. So in other words, immunity is recognised, it's just that states have agreed that once a case is up and running before the court, where it involves the parties to the treaty, then under those circumstances they have waived their right to claim immunity. We'll go into that argument in slightly more detail in class. So those are the basic concepts I want us to focus on. The basic concept of immunity, that a state is absolutely immune from the jurisdiction of foreign courts unless an exception applies, and the categories I want you to think about are civil cases before national courts, criminal cases before national courts, and criminal cases before international courts. Thank you for listening, and I look forward to seeing you in class.